Good afternoon. If I could ask the audience to please rise as our judges enter the room.
Please be seated.
It's my honor this afternoon to welcome you all to the final round of our Ben J. Altheimer competition. Before we get started, I would first like to give thanks to the Ben J. Altheimer Charitable Foundation that has helped fund the competition for years. The Altheimer Foundation has been a benefactor for the law school, not just externally, but also inside our walls, and has been very impactful. Each year they fund this competition, but they also fund support for our faculty. So I'd like to, at this time, recognize our Ben J. Altheimer Professor of Law, Rob Leffler. Rob, would you stand? And I'd also like to recognize and thank Professor Kathy Sampson for her leadership in our competitions program. And I'd like to thank our student leaders in the Board of Advocate for all of their hard work in putting this program together, and the competitors that we'll get to watch here in just a moment. We have a wonderful and well-respected bench joining us today, and I'd like to introduce the three of them before we get started. Presiding today is Judge Levinsky Smith. Judge Smith got both his undergraduate and JD degrees here on our campus at the University of Arkansas, and currently sits on the 8th Circuit Court of Appeals, where he's been a judge since 2002. To his right, we have Brandon Harrison. Judge Harrison is now on the Arkansas Court of Appeals, where he'll have an 8-year term. While he was a law student here in our building, he was on the Arkansas Law Review, and then had a private practice before beginning the election process for his current appointment. And then to our left is Justice Brown. Justice Brown has served for more than a decade on the Arkansas Supreme Court. He also did a great number of public service appointments in DC, both working for Dale Bumpers and Jim Guy Tucker. With that, I'm going to turn over the podium or microphone to our Board of Advocates representatives to further introduce what you're about to see and to introduce our competitors for today.
Hi everyone, my name's Kaylee Haywood, and this is my partner, Josh Allen. We have been hosting the competition this year and tallying scores and being up here many hours, so we've had a lot of fun, and I hope everyone learned a lot competing. We'd first like to thank all of you for being here. We really appreciated it. You know, all these competitors have put in a lot of hard work to get to where they are, and so I'm just going to talk a little bit about exactly what you have to do to be in this competition in case you may not be familiar with it. With moot court, you're arguing in front of an appellate court, so it's a little different than mock trial, which is what most people think of. You're actually arguing in front of a court of appeals, or in this case, they're arguing in front of the mock Supreme Court of the United States. To be in this competition, each of the teams has to first write a up to 35-page brief on the issues. And then after they write their brief, they then have to argue those issues in front of the judges. So not only do they have to show off their legal writing skills, but also their oral argument skills. So each team first has to argue their side of the brief that they actually wrote, so either for the state or for the individual. Petitioner is for the state, respondent is for the individual. So the first night they went on preliminary rounds, they went on brief, which means they argued the side of the brief they wrote, and then the second night of preliminary rounds, they went off brief, and they had to argue the opposite side. So they actually have to know the problem and all the arguments inside and out. After the preliminary rounds, that's when all their criteria is added up, everything's tallied up, and we figure in not only their oral argument scores, but their brief scores, and we put them down to the top 8. After the top 8, it was single elimination to the top 4, and now we have our top 2 teams here.
Before the court today, we have the case of State of East Jersey versus Phallic Gagan. Are the petitioners ready? You may proceed when ready.
Thank you, Chief Justice. Please. My name is Davide. I'm my co-counsel here represent the petitioner, state of Fiszer. The statute issue here today is carrying a dangerous weapon. In particular, the statute prohibits the carrying of any knife, fixed blade longer than 8 inches. As a tenet of his Sikh religion, the respondent believes that he is required to carry a kirpan at all times for self-defense. A kirpan is a large knife, and in this case, the respondent carried a kirpan that had a fixed blade of 9 inches. And on May 28th of 2012, he was in a public park openly carrying his kirpan. A police officer approached and asked if he had the required permit under the statute. He replied that he did not, stated that he had applied and was denied the permit because he could not articulate the actual need.
Counselor, how central to the religion of Mr. Gagan is the possession of this particular weapon?
It is the possession of a kirpan, I believe, is one of the 5 tenets of his Sikh religion. But the police officer then.
Does it have to be 9-inch blade length according to a religious tenet, or why can't it be 7 and thereby come underneath below the statutory threshold?
It can be 7, Your Honor. There's no requirement in the Sikh Code of Conduct that it be a specific inch requirement. It can be up to 3 feet, as little as a few inches. We ask that you reverse.
Well, what does that mean to the case then, from your perspective? If it can be less than 8 inches, that's what the statutory bar is it not?
Yes, sir.
Okay,
yes, sir.
so if the religious tenet doesn't require it to be 8.5 or 9, what does that mean for your case before this court?
Well, for our case before this court, if the respondent had just simply chosen a shorter kirpan, we wouldn't be here today. And we ask that this court reverse the lower court's ruling for 2 main reasons. First is that under the Second Amendment, this statute does not infringe upon any right that's been guaranteed to the respondent. And 2 is that even if it does infringe upon some right, it survives the appropriate judicial scrutiny.
Why do you say it doesn't impinge on some rights if you're talking about the ability to carry a knife outside the home? Why isn't that protected by the Second Amendment?
Well, in D.C. v. Heller and McDonald v. City of Chicago, this court established that the right to bear arms exists inside of the home for the purpose of self-defense.
Well, it didn't limit it. I mean, it said it's an individual right, but it didn't categorically say we're not going to allow it outside the home.
Certainly, Your Honor. That's the issue here today. This is effectively a case of first impression before the court. And we have to look to the lower court's rulings in the circuit courts to establish, or that's what we have as persuasive authority. The Second, Third, and Fourth Circuits have all held that that right does not extend outside of the home.
But Peruta and Moore, what is that, the Seventh Circuit and the Ninth Circuit said that it does.
Yes, Your Honor.
If there's a fear of, security reasons.
Yes, Your Honor. We would disagree with those cases. Those cases relied on the analysis that the difference between regulating conduct inside of the home and outside of the home, the court in Moore said that was an arbitrary difference. We would agree with the court in Kukowski in the Fourth Circuit. They said that has a critical difference regulating the conduct inside and outside of the home, or inside as opposed to outside.
But counsel, it seems that if a person's concern for carrying the weapon is both ceremonial and protective, that the protection should extend beyond the boundaries of their house. Some people live in rough neighborhoods, and being able to protect yourself in that area would seem to be quite strong.
Yes, Your Honor. The statute allows for that. Under the permit requirement, all the respondent has to do is articulate an actual threat or a particularized threat. And then he can take his arm anywhere that he so chooses once he has that permit. And also the statute allows for various exceptions that allow him to take it in his place of business, hunting or fishing, and it can be used in various target practice and things like that.
Many exceptions. How is this a generally applicable law if it's just out there for whoever it applies to?
Yes, Your Honor. Well, we argue that the exceptions actually strengthen the argument, the the state's interest in public safety and crime prevention. They allow
Well,
people.
it may on this issue, but it cuts the other way on the other issue.
Yes, Your Honor. In this case, the exceptions, much like the exceptions in Kikowski, had the same home and place of business exceptions for hunting and fishing and things like that. In that case, the court said that it strikes the proper balance between ensuring access to weapons for those who have a need for self-defense while preventing a greater than necessary amount of these dangerous weapons in public where the threat to public safety and the interest in crime prevention is at its greatest.
Is a park a sensitive place for Second Amendment purposes?
I believe there are some cases that have held that, yes.
I was under the impression it was an undecided question.
I don't know, Your Honor. In the cases we have in our record, I don't know. I can't
Well,
answer.
then, well, talk to me a little bit. If it is, why is it, and what does it mean for the analysis to the case if it is a sensitive place, or if it isn't?
If it is a sensitive place, Your Honor, then the state has a higher interest in public safety there. And respondent was in the park, yes, but he could have been anywhere. He was knowingly violating the statute. So where he was arrested, because he didn't have the permit, if he was in the park, if he was a block away from the park, it's not the issue here today, respectively.
Why shouldn't a permit be allowed for this type of situation where a Sikh is carrying a kirpan, which is part of his religious tenet? Why should the permit qualifications or criteria be limited to exclude something that is a religious tenet?
Well, Your Honor, if I may let my partner address that. I'm addressing the Second Amendment argument.
Right, but it's still, you mentioned the permit, and aside from the free exercise, shouldn't the permit be something that is the least restrictive way of interfering with a right, assuming there is a right outside the home to bear arms?
Least restrictive, I don't think, is the proper term, because that would imply that we're going to apply strict scrutiny here. We would argue that the court apply intermediate scrutiny. That's what the lower courts have done. And in that situation, the state only has to have a reasonable fit between its interest and the statute. And in this case, under the state's police powers, it has an interest in crime prevention and public safety. And there's significant evidence. In our brief, we cited 2 reports that showed that crime and homicide rates proportionally increased as the amount of weapons increased in the public.
I've got a follow-up question in this regard. What is the difference between a kirpan and a Civil War sword? I mean, you had Civil War swords, and no one was arrested for carrying those.
Yes, Your Honor. Well, they weren't arrested because they fit into the exception for the exhibitions and the historical parades and things like that. But the difference is that's a ceremonial piece. Now, the respondent claims that this is a ceremonial piece as a part of his religion, but in actuality, it is a sharp blade. He carries it for the purpose of defending himself and others. So the very tenet of his religion requires that it be capable of doing those things.
But, Counselor, you're not saying a Civil War era sword, even if it has an old and dull blade, could not be used to inflict serious bodily harm on someone?
No, Your Honor. I'm simply saying that in this situation, it fit within the exception. Respondent was carrying his kirpan, and had he somehow, was he a part of the parade, that wouldn't be an issue here, but he was carrying it knowingly violating the statute. Furthermore, the state legislature is better prepared than the judiciary to address these types of local weapon policies. This court stated in Turner v. FCC that it gives substantial deference to judgments of the legislature. And we feel that the East Jersey legislature here has balanced their interest in public safety and crime prevention against the individual's interest in bearing arms for self-defense.
But if this right extends outside the home as a fundamental right, then the judiciary becomes very much involved, does it not?
Yes, Your Honor, and that's where we would ask here to see that they have a reasonable fit under intermediate scrutiny. If this court doesn't hold that right extends outside the home, rational basis would apply under Heller, which only requires the government's interest be rationally related to the statute, which we would certainly pass in this instance. And going back to strict scrutiny, it's well applied that that only applies to weapons regulations that burden the very core of the Second Amendment. And in Heller and in McDonald v. City of Chicago, the core is the right to self-defense within the home. Exception 3B clearly removes that from the state's jurisdiction.
Well, how far from the home can you go till your rights diminish?
Your Honor, under the statute,
When you walk out the front door and stand on the porch, you have a diminished self-defense right?
Your Honor, it's unclear from the statute and the legislative history how they define the home. But I would say on the doorstep, yes. But I think whatever this court.
What about the curtilage of your property?
Perhaps
Does it extend that far?
Perhaps so, Your Honor. But in this case, he was not in the curtilage of his property. He was in the park. So that's not the issue here today, because he was.
Well, we have to think about this case, but we have to think about the implications of this case for future cases as well.
Certainly, Your Honor. And I feel that if another case came along in that light where someone was on the edge of their property, on the sidewalk in front of their house, something like that, that would be the proper place. Or maybe that the state legislature needs to address that. But if the court is to say this is the definition of the home, I feel like that's coming dangerously close to legislating from the bench.
Well, it seems like some commentators have said it's nonsensical to say that the language of the Second Amendment, the right to bear arms, is limited to what you can do around your home. I mean, it necessarily implies something that you could do outside your home.
Yes, Your Honor. That goes back to the language in Peruta and Morby Madigan, that they say there was an arbitrary difference. And going back to regulating conduct in the home versus in public, we would urge the court to accept the logic from Kikowski that it's a critical difference.
Counsel, to me, the critical difference here that I want to hear more about, and maybe we're running out of time, maybe your colleagues can address it, but if the religion does not require a 9-inch blade, then I'm a little unsure why the state isn't pushing that point harder. He's brought himself into the realm of a prohibition, but he could carry a 7-inch blade, be lawful, be compliant with his religion, case closed. I'm a little surprised you're not pressing that point clearer, or at least with more force. What am I missing?
You're not missing anything, Your Honor. That is exactly the case here. If he had chosen, and he did not have to choose this 9-inch blade, but if he had chosen a 7-inch, 6-inch blade, we could not be here today. May I have some brief time to conclude?
You can complete your thought.
Okay. There will always be someone with a knife 1 inch over the limit, no matter where this court or this legislature extends that. And we just ask that this court reverse the lower court and hold that the statute is constitutional. Thank you.
Thank you, counsel. Mr. Lang, respondent 1. Are we going to hear from the other petitioner, or are we going to do both petitioners, or then we're going to hear from the respondent?
I believe we're supposed to hear from both petitioners first.
All right. Mr. Fiszer.
Thank you. Chief Justice, may it please the court. My name is Eric Fisher, and I continue on behalf of the petitioner, the state of East Jersey, in the matter at bar. The issue before the court is whether the state of East Jersey violated the respondent's right of free exercise when it enforced the provisions of a statute that is both neutral.
Mr. Fisher, would you speak more directly into the microphone?
Absolutely, Your Honor. The issue is whether or not the statute violated the respondent's right of free exercise when it enforced the provisions of a statute that is both neutral and generally applicable. The lower court ruled that it was a violation of the First Amendment right and applied strict scrutiny. This is error, reversible error that this court should correct for the following reasons.
Let me interject something. It is my reading of the record and my recollection of it is that the state Supreme Court decided the case, addressed the Second Amendment issue first, stated that it could have stopped there, but it didn't because of the movement in the area of the law, and it went ahead and addressed the First Amendment claim. Do you think we should follow suit if we held in the state's favor on the Second Amendment claim? Should we go ahead and reach the First Amendment analysis or not?
Your Honor, I would disagree with the lower court's articulation there. Even if the Second Amendment issue is decided in the same way it was there in the lower court, there's still enough of a ground there for a First Amendment claim to exist, and therefore the court should consider it here today. The main reason why the statute is constitutional here and doesn't infringe on the free exercise right is because under the analysis laid out in Smith, it is both neutral and generally applicable.
Counsel, I addressed a question to the first petitioner related to the exceptions that were being listed as present in this statute. Don't the presence of those exceptions cut against the general applicability nature of the statute?
No, Your Honor. All those exceptions exist to enhance the protection of the public. If we look at the list of exceptions on page 12 in the record, we see the police officer can carry the weapons, government officials can. Even the exceptions like for hunting and fishing, the person can only use the weapon while actively engaged in hunting and fishing. While transporting the weapon, that weapon has to be not loaded, has to be broken down in a compartment that is inaccessible to the person.
But someone's religion is not so compartmentalized. They can't just pull it out of a case and then use it. It's part of who they are and part of their belief system. How do you reconcile the difference between hunting and fishing and someone's religious beliefs?
Yes, Your Honor. If we look at the facts, we see that if he had simply carried a blade that was 1 inch less, we wouldn't be here today. He could have complied with the law and his religious belief, and this court said in Reynolds that the First Amendment is never an excuse for criminal behavior.
Stops the legislature from next year making it a 5-inch blade. I mean, they're in control of the laws. At what point will there be an infringement? 4-inch, 5-inch, 7-inch? You see my point? It's 9 today, and if it's, at some point the kirpan probably ceases to be a kirpan at some length, uncertain, I don't know what it is, but for practical purposes, where does that line drawn from the state's perspective where it will let it lie?
Your Honor, the best authority that we have on point is the case of Smith. In that case, an individual, the court stated that the use of peyote that violated the criminal statute there, even though that was supposed to be central to his particular religious beliefs and practice, that was not allowed for. So even if the statute here was written where he couldn't carry his kirpan, then still the burden on his religion does not outweigh the state's interest here.
So now we've gone from an 8-inch blade, a 7.5 or 8-inch blade would be okay, but now nothing's okay, conceivably? Is that what I hear you saying?
No, Your Honor. That's if we were dealing with a different statute. The issue here today is a statute that exists that we have here.
But my colleague, Justice Smith, the Chief Justice, said, what about the next case? All this could be undone in one legislative session. It could go from 8 to 1 inch in one session. I mean, it doesn't take long to affect change. It just change a number in the statute.
Well, absolutely, Your Honor. And to this point, the best authority that we have is Smith in showing that the laws that regulate general conduct never give way to religious belief. And we ask that this court to reaffirm that principle here today. When the state is regulated in a manner where it regulates general conduct and it's not specifically targeting a religious belief, then those types of statute has always been upheld by this court.
Well, that's the key here, whether it's the neutrality, general applicability, or whether there has been some kind of targeting. And aside from the fact that you have all of these exemptions for governors and legislators and even judges, to carry these weapons, the thing that concerns me is you do have the case of the Kukumi case and the Santerias, where they were sacrificing animals, and the court held that this was directly related to religious practice. Now, why wouldn't that pertain to this situation where they're arresting one man with all of these weapons around like Civil War swords, arresting this one man for carrying a kirpan for ostensibly ceremonial reasons? In other words, I'm asking you to try to distinguish the Kukumi case.
Yes, Your Honor. In Lukumi, we see the legislative history showed that those provisions were created because the city knew that these practices were occurring, and they provided for secular exemptions for almost every other area for the sacrifice and slaughter of animals, but specifically targeted this particular group. If we look at the language of the statute, that's not here today. And in this particular case, what we saw outside of the parade was that all those individuals that were at the parade were carrying ceremonial pieces. The fact show they were firing off blanks. The rifles were discharging blanks and not actually firing live ammunition. They were in compliance with the statute. That was in a controlled environment that officers were around. And whereas the respondent, 30 minutes after the end of the parade, was walking away from it, and he was openly carrying this dangerous weapon, and the police officer then approached him.
Are you saying that he was arrested because he left the area and still had it with him, just like everybody, but everybody else had to do the same thing? Everybody had to get back to their car with their weapons. I mean, you're gonna. They had a permit to use it in the parade, and their argument I keep reading is, but people were carrying theirs back to their cars, yes, but they had permits. But I mean, he was in the park area, and I don't see the point of well, I'm losing my thought here about everybody else is walking home, and he's walking home and he still has it, but everybody else has their weapon too at the time. I mean, why weren't they arrested at that time? When did the permit for them having, when did their permit lapse?
Yes, sure.
That's a bad question, a bad hypothetical, I'm sorry, but I've seen it in the briefing materials, and I can't quite connect why it matters that everybody's walking to and fro with their guns and all that. I mean, so what?
Yes, sure. Now, the record doesn't mention at all whether or not other people were carrying their weapons to their vehicles. We can assume that perhaps they did, but there's nothing there that shows that it does. But as far as the statute itself, to answer your question,
I don't think there was a question there, but if you can find one there, you're brilliant. Go for it.
Yeah, yes, Your Honor. When dealing with the statute, for them to be in compliance, they just simply, while they're in an environment, they can have those pieces and those rifles, those ceremonial swords, but they just have to follow the statute in dealing with the transportation of those weapons, so long as they're secured and not openly carried in the manner that the respondent is, then they're fine. They can transport those pieces outside of that area or go put them away. But the issue with the respondent is he was openly carrying this and knowingly violating the statute. When he applied for the permit, he knew what the requirements were.
Would the state support a permit situation for religious practices? As I understand it right now, it's a threat or self-defense, whatever, grounds for a permit. What about for a religious tenant? Would the state support an amendment to the permit procedure to provide for a devoutly held belief such as we have here in this case?
Your Honor, as the way the statute is written currently, no, Your Honor. Now,
Well, of course, it's not written that way now. Would you support that in the future is what I'm asking.
Your Honor, the legislature may or may not. Petitioner's not able to speculate as to whether or not they would do so in the future. But providing an exception in this case for the permit would give him, as a citizen, a private right to not comply with a neutral law of general applicability.
Counsel, what is the other side's best argument against your position, and why is their argument wrong or not the one we should accept? What's their best argument against you? I want to know what you think about that best argument and why we should not adopt it.
Their best argument, Your Honor, is that the law is not generally applicable because all of these secular exemptions would, in effect, undermine the purpose of the statute, that it hinders the public's safety, and that providing an exception here for the respondent wouldn't pose any more threat than these secular exemptions. So if the law is not generally applicable, then strict scrutiny is applied and the statute may or may not fail. But the exceptions themselves do not pose the same type of threat here. The these exceptions do not allow for any individual to carry a dangerous weapon in public, whereas if an exception is granted for the respondent in this case, he can openly carry this weapon anywhere.
Well, aren't certain exhibitions done in public? One of the main exceptions under the exceptions 3E, conducting any sort of exhibition which requires the use of a dangerous weapon. That's exception big enough to drive a truck through.
Yes, right. At first glance, it would appear so. It's listed along with exceptions such as the parade and others. And the purpose of the statute there is to make sure that if there's going to be an exhibition of that type or a parade, that it's done so in a controlled environment. At least, for example, in the case of the parade, at least the state can come in and at least have some control over that particular area, whereas here, that's not the case. The respondent's going to be able to carry this weapon on his person, which he believes he has to carry for his self-defense and others at any time, in any location. And it's not just him. The article that's cited to in brief shows that the population of Sikhs is in excess of 200,000. So if you provide an exception here today for one person, it won't just be the respondent, it will be others in the future.
200,000 in the state of East Jersey?
Nationwide, Your Honor.
Nationwide.
The census
in East Jersey?
Census did not list that, Your Honor.
So maybe as few as 10, 50, 100. We have no idea, do we? Could be one.
Sure, Your Honor. But it's not just the state of East Jersey here today. It's also other states that will have similar laws be challenged on the same grounds across the nation. So we'd ask the court to consider the fact that this does have...
But this is an as-applied challenge, isn't it, to Mr. Gragan himself? I mean, it's not... That's what I understood the challenge to be, an as-applied to him, not strike down the statute all across the state.
Absolutely, Your Honor.
Okay.
And as applied, even if it's just one person, the one person still must give way to the state's ability to regulate general conduct. And that principle was established in Smith, and we'd ask the court to reaffirm that here today. This particular case isn't even going as far as Smith. Here, he can still comply. He can observe his religious beliefs, carry a kirpan of a shorter length, and comply with the law. But he knowingly chose not to do so.
But you're making the point that the difference between a 8-inch blade and a 7-inch blade makes that much difference to the safety of the public? Is that the position the state's taking?
No, Your Honor. The position the state's taking is that we'd ask the court to give deference to the legislature in the state to best determine how to protect its citizens. Now, the state has had to draw the line somewhere, and it's chosen 8 inches here. And traditionally, the court has not has allowed the state to be granted that deference to determine for itself where to draw the line or how.
How much less dangerous is a 7-inch blade than an 8-inch blade?
Well, Your Honor, probably not much in the aspect of they're both sharp, and they both have the potential to do harm, but the statute has been written as such as to draw the line at 8 inches. And we'd ask the court to give some deference to the state as to determine how to draw those lines. When the state is regulating conduct that is general in the manner in which it is here today, this court has always stated that the First Amendment cannot be used as a shield or an excuse for criminal behavior. And it is for that reason that we ask this court to reverse the decision of the lower court. And we thank you for your time.
Thank you, Mr. Fisher. We're going to take a short break between our petitioners and the respondents. Okay. This way.
That's good.
I don't need one. If we want to keep going, we can. Unless, the reason if you're wondering what's going on, the order of proceedings call for a short break to allow people to exit and enter if they needed to. So I assume if there's somebody who need to hurry out for class, you can at this moment. Otherwise, we're just going to keep moving and have our first respondent come forward, Mr. Lang. Mr. Lang, you can proceed when you're ready.
Good afternoon, and may it please the court. My name is Caleb Lang, and together with co-counsel Joe Woodward, we represent the respondent, Mr. Gagan. I will address Mr. Gagan's Second Amendment claim. This court should affirm the East Jersey Supreme Court's ruling that the East Jersey Statute 4570 violates Mr. Gagan's Second Amendment right. First, the right to openly carry a knife falls within the scope of the Second Amendment. Second, an intermediate standard of scrutiny applies. But because the statute is overly broad by preventing the possession of virtually any weapon capable of producing serious bodily harm, there must be a tighter fit between the government's important interest and the means it has chosen to pursue that interest.
Now, counsel, you don't contend that the Second Amendment right to bear arms is absolute, do you? Meaning you can take your weapon anywhere at any time. Is that your position?
Your Honor, it is our position that the Second Amendment right is not absolute, just like as this court has noted, no right is absolute. So
what is the difference between Mr. Gagan taking his Kirpan outside and someone taking a loaded .32 pistol outside and going to the park, as far in your estimation? Are we on a slippery slope here is what I'm asking, with respect to weapons and the right to bear arms?
Well, Your Honor, we concede the state obviously has a strong public interest in the health and safety of its citizens. And it's obvious that a firearm poses more of a threat to that public safety than to a knife. But the issue in this case is the statute...
Well, are we getting involved in gradations between weapons, like what was being asked by Judge Harrison about the length of the blade? I mean, we're talking about a sharp knife, we're talking about a .38 pistol, let's say. Again, slippery slope. And let's say both persons carrying the weapon feel that they need it for self-defense.
Yes, Your Honor. As this court has noted in D.C. v. Heller, that the Second Amendment does not apply to certain weapons. This court has already made that distinction. For example, when this court did an analysis on the definition of the word arms within the Second Amendment, this court specifically determined that that did not apply to weapons specifically designed for military use or used in a military capacity. So that means that obviously a citizen can't walk down the street with a bazooka or a machine gun. That the purpose of the Second Amendment was to prevent the elimination of the militia. And the idea behind the militia was that...
Let's bring it down to your client. Why can't your client carry a 7-inch blade Kirpan and be fine with it? Why can't that happen? Why does he insist on a 9-inch in this case, a 9-inch blade?
Your Honor, we contend that even if Mr. Gagan carried a 7-inch Kirpan, he could still be found to be in violation of the statute. If the court would refer to page 12 of the record, specifically under the definition section of a dangerous weapon. A dangerous weapon is an item capable of producing death or serious bodily injury to a person, including various weapons that automatically fall within that exception, and then a knife that has one or more of the following, and then a fixed blade longer than 8 inches. Now, it's important that this list is not all-inclusive, meaning that even with a 7-inch knife, it could still be an item capable of producing death or serious bodily injury to a person. And that's what we are contending. This statute is overly broad. Even under this statute, a taser, for example, could be an item capable of producing death or serious bodily harm. Pepper spray could even fall within that definition in certain situations. If you permanently damage someone's eyes, you could be found to be in violation of the statute. So this statute is overly broad than just if we were dealing with just firearms. And that is why the state must have a much tighter fit between its important interest and the means it has chosen to pursue that interest. Because we're not just talking about firearms or knives or about one category of weapon. We're talking about virtually all categories of weapons for self-defense.
I was interested in one comment you made about the Second Amendment only applies to militias. Is that the case? Didn't the Heller case and McDonald cases suggest that it's an individual right and not just limited to militias?
Yes, Your Honor. This court specifically stated in D.C. v. Heller that the purpose of the Second Amendment was to prevent the elimination of the militia. But when this court looked at the Second Amendment, it said the purpose clause did not inhibit or restrict the operative clause, which that is an individual right of self-defense to carry weapons in case of confrontation, and particularly for defensive purposes.
So if I decide one morning, or let's say Memorial Day, that I want to go to this park for the celebration, and I'm worried about self-defense, I can just arm myself with a Kirpan or a pistol or whatever and go to the park if I have it in my mind that I'm worried about security. Is that basically your position?
Your Honor, we are stating that the Second Amendment has a right to self-defense, but we are not stating or contending that the state cannot regulate the Second Amendment. I mean, the very text of the Second Amendment states a well-regulated militia. The state can regulate the Second Amendment to protect the health and welfare of its citizens. And for example, under this statute, it does not allow a typical law-abiding citizen to carry an arm for self-defense. If the court would refer to page 16 of the record, particularly note 4, Mr. Gagan was denied a permit even though he complied with every other requirement under the statute, but he could not demonstrate a particular threat to his life. So, as the court in Peruta stated, the question is not whether the statute allows some people to bear arms outside the home in some places and at some times. Instead, the question is whether it allows the typical, responsible, law-abiding citizen to bear arms in public for self-defense. And it's clear that under this statute that is not allowed, or not an adequate requirement to receive a permit. The state could have...
I don't think a permit is necessary under your rationale. You don't need to get a permit as a prerequisite to carrying the Kirpan, for example.
Your Honor, we believe that there is actually, the state has an interest, and that a person who is not capable of handling a weapon safely is a menace to both themselves and to the general public. But there are other less restrictive means that the state could have chosen to pursue that interest. For example, based on the statutory scheme, the state could have required a mental health examination. They could have required a longer training period before a permit is issued. They could have required more periodic check-ins to make sure that the citizen can adequately and safely handle a firearm than just limiting a permit to someone who has to demonstrate an actual threat to their life.
So in essence, the only way you can get a permit for self-protection is if you're being stalked.
It's clear under this statute that just a general desire for self-defense, you have to demonstrate articulable circumstances that would warrant the issuing of this permit. So it's clear that just saying, I have a desire for self-defense, I want to go through this permit system, that is not enough for a permit to be issued, Your Honor. That's correct.
Is a park a sensitive place?
Your Honor, I believe that a park is a public place. Personally, I believe a more sensitive place that the state obviously has an interest in regulating the possession of dangerous weapons would be someplace like a bar where alcohol is consumed. That would most likely be a dangerous place where the state obviously has an interest in protecting its citizens.
What are your thoughts on if a park has 5,000 people on it, in it, and women, children, people frolicking around, and someone with a 9-inch blade decides to just run rampant? Isn't there a chance for mass casualties and damage pretty quickly, even with a knife and one man?
Yes, Your Honor, there absolutely is. And
does that help get us to a sensitive place analysis or not? Talk to me about why you think it's not sensitive. I assume you don't want it to be because there's a lower scrutiny level. Is Is that right or not right?
Your Honor, I believe the issue, there is another way that the state could protect the interests of those citizens than just saying you cannot carry this dangerous weapon in a public park. For example, what I said, the state could have chosen under the statute to allow a mental health examination to determine.
But let's return to what I think I'm trying to make a doctrinal point. Do you want it to be a sensitive place or not? Does your client argue for a sensitive place characterization or not for a park?
We are arguing that a park is not a sensitive place. Your
Okay.
Honor.
And what's the consequence of it not being a sensitive place? A lower scrutiny level, is that right? Or a higher scrutiny level?
From my understanding of the District of Columbia v. Heller, this court specifically stated that nothing should be cast into doubt on longstanding prohibitions on the possession of weapons, such as felons, those by the mentally ill, and possession in public places. So those situations would fall outside the scope of the Second Amendment, just like this court has stated that certain weapons fall outside the scope of the Second Amendment. For example, in this court's decision in Heller, this court looked back and analyzed its decision in United States v. Miller to state that the Second Amendment did not protect a sawed-off shotgun because they noted the typical law-abiding citizen would not have this weapon because it was not in common use at the time, and further, that there would be no real reason that a person would need this in the militia, which the Second Amendment was created to preserve. And further, yes, Your Honor. Does that answer your question, Your Honor?
Sort of. Could a park be a sensitive area sort of circumstantially? If there's a parade going on of the type here and someone knows there's going to be more people there, or you can look and see and there is, does that have anything to do with whether it can circumstantially be a sensitive area?
Your Honor, just so I understand your question correctly, you're stating that
With no one but your client in it is not quite the problem as your client in it with a 9-inch blade, perhaps with 10,000 people in it. You see my point?
So just so I understand that when there are more people in a certain area, that makes it a sensitive place?
Could it? Could the sensitive place analysis be circumstantial, meaning the circumstances help dictate whether it becomes sensitive or not? I don't know. I don't have the answer. I'm just asking for your input, your thoughts.
I believe that circumstances can indicate whether a...
You said alcohol in a bar. I take people and alcohol and weapons being the circumstance that you're getting at. I mean, you're tracking with me, I think, or I'm tracking with you. So why couldn't a park be something similar, even if there's no alcohol involved? Maybe it's the number of people, or people being less on guard because they're having fun, and as I said, being engaging in frivolity and family time. Why couldn't that be something in the mix, the analytical mix, or should it or shouldn't it? I'm just trying to have a conversation with you about it.
Yes, Your Honor. I think it's dangerous to recognize that the circumstances based on the number of people in a certain area, that makes it a dangerous location. For example, what if you're in your car on the freeway and there's a traffic jam? There's a lot of people, there in that circumstance. Does that make the free...
Cages, though, with door locks.
I'm sorry, Your Honor.
They're in steel cages with door locks, not outside running around with their persons open to the air and to the next person without some means of protection in between them. That strikes me as a difference there.
You could... So in that circumstance, an individual could perhaps be carrying a firearm, which that would easily go through a window, and even with a knife. In Mr. Gagon's case, you could easily smash a window and...
But someone who had a loaded pistol outside a case would be in violation of the statute, wouldn't they?
Can you restate that question, Your Honor? Sorry.
Someone, if they had a pistol, if they're in their car with a loaded pistol outside a case, they'd be in violation of the statute, because I think the statute requires the separation of ammunition and the weapon to be cased. So there could be a violation in that area too. Anyway, I'm just sort of probing the notion of a special place. That's all I'm doing. I don't mean to.
I'm curious, Mr. Lang, what you think should have happened in this case. Should the officer just have ignored Mr. Gagin, or what should have happened when he observed him with this Carapan at the Memorial Day celebration?
Your Honor, we contend that the officer acted reasonably. This is what any officer should have done. You know, even if an individual has a permit, because an officer needs to obviously know there's public safety implications on whether someone is carrying a weapon in order to commit a crime, for example.
So
And
the arrest was appropriate?
under the current law, the officer was acting, he was performing his duty under state law.
And the conviction was appropriate, and the sentence?
Under state law, yes, but Your Honor, I see that I'm out of time. May I briefly answer your question? Conclude.
Yes, go ahead.
Under state law, the officer was acting correctly, but the issue in this case is that the statute is overly broad and violates the Second Amendment and does not allow the preservation of the militia.
All right, thank you.
Thank you, Your Honors.
Thank you, Mr. Lang. Mr. Woodward?
Good afternoon, Your Honors. May it please the Court, my name is Joe Woodward, and I also represent the respondent, Mr. Gagan, on his First Amendment claim. The Court should affirm the ruling of the Supreme Court of East Jersey that dismissing the conviction and the indictment of Mr. Gagan. The State Supreme Court correctly held that East Jersey Statute 4570 is unconstitutional for 3 reasons. First, Section 3 creates several categories of exemptions for secular conduct without extending the same exemptions to religiously motivated conduct, making it under-inclusive and therefore not generally applicable.
Counsel, is there anything in the record to indicate that resulted from some targeting on the part of legislative officials?
Your Honor, we are not challenging the facial neutrality of this statute. We're actually conceding that it is facially neutral. There's no explicit targeting of any religious groups within the statute. However, we are arguing that it is not generally applicable to the citizens of East Jersey.
Why not?
Because of the long list of exceptions contained in Section 3 of the statute, Your Honor. As you've already pointed out, there is this huge list of exceptions. I believe there are 14 in all. When legislation allows secular exemptions that substantially undermine the purpose of the law, but does not allow parallel religious exceptions, the law is not generally applicable.
Well, I'd like to ask a question about that. When I read these exceptions, it could arguably be read as a small list, could it not? I mean, you only have one governor, and I don't know how many law enforcement officers, a number of course, but they need their weapons. Why can't this list be read as being very narrow, a narrow class of people, and some just very particular people?
Well, Your Honor, because of the language in the statute, you can see that any person in a civic organization while parading is allowed to carry a weapon. Similarly, provisions D and E allow people who are conducting exhibitions to have these dangerous weapons in the public. This could apply to anybody under the statute.
Why doesn't the Smith case, the Peyote case, really govern this situation? I mean, that was a situation where it was generally applicable, and there was this, but it was determined by this court that the use of peyote for the religious ceremony was could not be condoned. It was illegal. Why doesn't that same factual situation pertain here?
Your Honor, the peyote situation in Employment Division v. Smith did not contain, the statute prohibiting the use of peyote did not contain these types of exceptions that you can see in Section 3. It applied to all members of society. It didn't accept, for example, the governor or members of the legislature and allow them to use illegal drugs such as peyote. It applied to all members of society equally, despite whatever religious or personal beliefs that they might have.
Can a statute not recognize the public nature of a position and the decisions that some public officials must make, which are very unpopular at times and anger people and infuriate many people, and thereby put their personal safety at issue, arguably? Why why is that a problem for a state legislature to recognize that some public officials have put themselves out there and they are therefore at a more identifiable risk to their personal safety? Why can't that be worked into a statute like this?
Well, Your Honor, there's actually a very recent example of this from Arkansas, where State Senator Jeremy Hutchinson, an advocate of arming teachers in schools, was at a live fire demonstration training exercise for teachers. He accidentally shot one of the teachers in the training exercise by mishandling his weapon. That goes to show that just because a person is a member of the legislature doesn't mean that they necessarily know how to safely handle these weapons. And that's our concern.
Well, that may or may not be the case, but I think the thrust of my point is, aren't some public officials, by the nature of their duties, more susceptible to being the targets of other people's ire or hatred?
Yes, sir, that is very likely.
If that's at least possible, rational or what have you, then why can't this statute reflect that potential reality? It may vary from year to year or what have you, but I think yours is an exception where a tragedy happened, but I don't know that really speaks to the statute and the purpose behind the statute.
Your Honors, the purpose behind the statute is to protect civilians, and I believe that the Senator Hutchinson example illustrates the danger to the general public in arming certain members of society. Do we have any information in the record below about whether the Sikh religion happens to be any more dangerous than any other religion? There is no evidence to reflect that they are any more dangerous than any other religion, Your
Is your client a law-abiding citizen, as
He
best we can tell from the record?
Yes, Your Honor, he absolutely is. As noted by the trial court judge, this was Mr. Gagan's first conviction.
What is the standard of review in this case, in your judgment?
We believe that the standard of review should be strict scrutiny review, Your Honor.
All right, compelling state interest.
Your Honor, we would concede that the state does have a compelling state interest in regulating for the health, welfare, and safety of its citizens. However, this statute is clearly not narrowly tailored. It has not only Section 3, which contains 14 different exceptions for secular conduct.
How many would suffice to keep it constitutional?
I'm not sure that I understand your question, Your Honor.
Say 13 is too many. How many is okay?
Well, Your Honor, adding one for sincerely held religious beliefs might completely clear the situation up.
Well, if you have a compelling, and we're talking about narrowly tailoring, which is what Judge Harrison's question is going towards, but why wouldn't this be something where it is narrowly tailored to dangerous weapons with, what, about 10 people being, or 10 categories being excluded? Why doesn't that suffice as something that is narrowly tailored?
Because of the burden that it places on the religious activity, Your Honor, in this case, it shows that the statute is not narrowly tailored to meet the state's interests.
Do we know in the record if your client would be violating his religious conscience if he did not carry this item in public every single time?
Carrying the knife itself, Your Honor?
Does he have to have it with him at all times when he's in public, or does wearing it on occasion suffice to meet his religious tenets? How strict is the requirement?
Your Honor, carrying the kirpan is one of the central tenets of the Sikh faith, and the rationale behind carrying the kirpan is to be able to, at a moment's notice, defend yourself or others if the need should arise.
He can't do it in an airport, can he?
Carry a weapon?
He can't carry his kirpan through security and into an airplane, can he?
No, Your Honor, he likely would not be allowed to carry it into an airplane. However, he would likely be able to stow it in his bag and retrieve it almost as soon as the plane landed. And further, we have certain measures in place that allow for the safety of passengers on airliners, such as air marshals.
Well, I guess I'm in the realm of balancing here. You've got legitimate state interest in protecting the citizenry in this park on Memorial Day, where there are children and families and whatnot. And then you've got the lone Sikh with a weapon. admittedly a dangerous weapon. I don't think anybody really refutes that. So why doesn't the state win out in this regard as far as trying to protect the citizenry when the idea of carrying the Kirpan is self-defense and protecting others, which means the Sikh could, Mr. Kagan, could draw it at a moment's notice and go after someone?
Your Honor, the reason the state does not win in this situation is because of the substantial burden placed on all religious exercise of this nature by the statute. The actual need language contained in Section 2 of the statute, the permit section, is very analogous to the good cause language seen in previous Supreme Court cases that created systems of individualized exceptions. As stated in Bowen v. Roy, granting exceptions from a statute for good cause, or in this case, actual need, creates a mechanism for a system of individualized exceptions. And further, whether or not a person has carried their burden to show the actual need under the permit requirement is left to the sole discretion of the director of the Department of Safety of East Jersey. If a state creates a mechanism for a system of individualized exceptions, its refusal to extend an exemption to a case of religious hardship suggests a discriminatory intent. So here the statute specifically makes exemptions for those individuals who need the weapon for their employment, but there is no such exemption offered for religious conduct.
Well, this just struck me. An interesting thing about, an interesting aspect of this religious tenant argument is not just his own protection, but the protection of others. But the state is charged to protect its citizenry through law enforcement. Why should your client's religious tenant, not to protect himself, let's say, but to be the protector of others when that is the state's job? Why should his religious faith in that regard trump the state's? That's a state police power protecting its citizens. That's not the religious tenant's job to protect others. That's the state in this secular government. What do you have to say about that? That one aspect, I understand the ceremonial aspect of it, but the protection of others, he's not charged under the civil law to protect others. The law enforcement is.
That's very true, Your Honor, and by no means are we advocating that Mr. Gagan take up vigilantism in this regard.
Well, then what's the point of, then it's an idea of the protection of others, not he's actually going to wield it and go cut a criminal, instead of call for law enforcement. I mean, shouldn't he call for law enforcement? Or it's just, I don't know.
The call for law enforcement should always be one of the first and foremost things to happen in an emergency, Your Honor. However, in an emergency situation, law enforcement isn't always available. Sometimes we have to use whatever is necessary around us to help defend those people. To help defend the public. And if Mr. Gagan, his religion requires him to do that, then saying that he can't carry this doesn't exactly mesh with the purpose of protecting citizens. Does that answer your question?
I understand your point. I do, yes.
Because the statute creates a permit system that allows for individualized exceptions based on the determination of one governmental official, this case is entitled to the individualized exception theory espoused in Employment Division v. Smith.
Well, how would you draft the permit section to take care of religious tenants and Mr. Gagan, and I'm probably mispronouncing his name, but his dilemma?
Well, Your Honor, adding a simple provision to section of the statute 2A, maybe possibly 3, that would allow for sincerely held religious claimants to undergo this same or maybe even a heightened permit requirement, maybe make them go through heightened permit requirements such as more training or...
and then you get into the realm of what is religious and what is a sincerely held religious belief.
Well, that would be for the court to determine at a later date, Your Honor. This court.
Legislature?
Or the legislature, absolutely. The state here has conceded that Mr. Gagan's belief is sincere and that he has not brought this claim frivolously.
Counsel, in the time you have remaining, what is your opponent's best argument against your position, and why should they not prevail on that point? Maybe an unfair question with 1 minute left, but if you'll do your best, I know it's hard.
Your Honor, our opponent's best argument is that this statute does not overly burden our client's religious belief. That while he is entitled to believe whatever he would like to believe, he may not always be entitled to carry out those acts. We would argue to that point, however, that the state has unduly burdened his ability to carry out one of the central tenets. The state has criminalized one of the central tenets of the Sikh faith. And as Bowen v. Roy stated, Your Honor, I see I've run out of time. May I have a brief moment to conclude my statement?
Conclude your thought.
The nature of the burden imposed by the government is relevant to the standard of review, as stated in Bowen v. Roy. Here, the state has criminalized a central tenet of the Sikh faith, which has placed a large burden on the ability of any Sikh within East Jersey to effectively practice one of the core tenets of their belief. For the foregoing reasons, we pray that this court affirm the judgment of the Supreme Court of East Jersey and vacate the indictment and conviction of Mr. Gagan. Thank you.
Thank you, Mr. Woodward. All right. Do the parties reserve time for rebuttal? Mr. Jones? James. Excuse me, get your name. Go ahead.
Thank you. Chief Justice, may it please the court. The Second Amendment issue today boils down to whether or not the court here will give deference to the state to protect the public, or whether it's going to allow the individual to determine how best to protect themselves. The state legislature has looked at the evidence and then it is seen that when the dangerous weapons are in the
Well,
public.
you're not arguing against individual rights, are you? The public versus individual rights.
Absolutely not, Your Honor. Just here that the state has this interest that outweighs the interest under the Second Amendment. They have looked at the evidence and seen that when dangerous weapons are possessed in public like this, it increases the crime rates, homicide rates, whether it's firearms, knives, and things of that nature. And they are attempting to protect the public. And like here in this case, when people are around a public park or in public places of that nature, the police and the state are best left to determine and protect its own citizens, not the individual carrying a firearm openly in public, or a sword in this case, that at any time can be pulled out and used. A sword that he believes himself he must carry to defend himself and others. Under the First Amendment, it's exactly this type of belief that shows that he is unwilling to comply with a neutral law of general applicability. He could have complied and carried a shorter ceremonial sword and still observed his religious beliefs, but he willfully chose not to and carried one in excess of the statute's requirements.
Well, what quickly about the counterpoint, which I think was a good one. If it was it's the dangerous weapon aspect of the statute that is at issue here. So it's not necessarily the length, which we were getting at quite a bit, but also the dangerous nature of a knife in general that's prescribed.
Your Honor, I see my time's expired. Can I answer your question briefly?
You may complete your thought.
Thank you, Your Honor. The statute itself is not as the respondents have characterized it. it doesn't regulate any dangerous weapon. It's clearly listed what items are to be regulated. It's stated whether it's going to be a firearm, whether it's going to be a knife, of what length it's going to be, whether it's going to be a folding knife or a fixed blade. It's clearly outlined what is to be regulated, and it doesn't leave room for the respondent, in this case, to carry this particular dangerous weapon that is a threat to the public. And it's for these reasons that we ask this court to reverse the decision of the lower court, and we thank you for your time.
Thank you, Mr. James. Mr. Fisher? I think that was Mr. Fisher. Was that Mr. Fisher?
You did the rebuttal.
Two.
That's all we have. All right. Now, we'll turn to respondents. Do you have any rebuttal?
Your Honor, we're not afforded time for rebuttal.
Well, then, that will conclude this argument. Court will take your case under submission. We will render a decision in due course, and we thank the parties for their argument and briefing, your participation in helping the court wrestle with some very difficult issues. Thank you. Court will be in recess. While in law school, the pressures of classes and papers and approaching exams are sufficient for most students, but the additional experience of preparing a brief, preparing an argument, learning how difficult it is in reality rather than just kind of in theory is a very, very good experience. And many law students do it, but many don't. And I think those that don't do themselves a favor by avoiding the additional work that comes from participating in moot court. So I commend you all for making the choice to participate and laying out the extra time and the effort it took to do what you've done. Overall, I'll just start and give a few comments. I noticed for both of the petitioners, we had, and I speak for myself, I'll say we, but I'm speaking primarily for myself. I had a little bit of trouble hearing you initially. You need to be a little more assertive with your voice. We don't need you to come and bellow at us, but you do need to speak up assertively and with confidence about what it is you have to say. And you don't want the judges kind of straining to hear you. You want them to be able to hear you clearly. And it's not uncommon for that to be an issue, but I would comment on that for the petitioner side. Additionally, I think both of you on the petitioner side showed good command of your law that you were dealing with. It seemed the questions came at you a little early and quick and sometimes from left field. But that's the reality of oral argument. It works that way sometimes. You can't ever be completely aware where the judge's questions are going to come from. And so you have to do the best you can with what they throw your way. But I thought you handled yourselves well in that regard.
Yeah, I would echo that. When I did moot court back in the dark ages, and it was a long time ago, I remember the criticism I got back was you had a pretty good knowledge of the field and whatnot, but you didn't come on like gangbusters. In other words, I was a little bit too reserved. And I thought in some instances, you have to kind of walk a narrow line between being too reserved and being confident. And I thought for the most part that the four of you did an excellent job. I mean, I've watched, I don't know how many oral arguments over the years and participated in them, and you all rank with the ones who really are accomplished, and you've got a good future in store for you. So I really compliment you for the work you put in on this and your ability to stand before, three judges and articulate your views as well as you all did, because I understand the most terrifying thing in human experience is public speaking. So you all acquitted yourselves well, and I compliment you for that. I thought you all did a good job as far as eye contact, being poised, looking, gesticulating appropriately, and not being over the top. But I guess in some instances, and I think, Caleb, you were the exception, you were pretty passionate, but I think you need a little more passion, as I needed back when I was in law school. That's not to say you didn't articulate well and you weren't confident in what you said. The microphone, I'm going to echo what Judge Smith said. The microphone is so important. I mean, the exercise is meaningless if you can't be heard. So I think, Caleb, you did not have that problem, and I think, Mr. Woodward, you did initially, you did, but you overcame it. You came back louder and clearer, which I thought was good. I compliment you on rolling with the punches because we hit you hard. You know, we didn't ease up on you, and that's what happens at oral argument. Is if you go into appellate practice, you'll find that out. But I thought generally it was very appropriate what you did, very impressive what you did, and I think you all have a very good future in store for you if you decide to go into appellate practice, which I think you should. So thank you very much. It was a privilege.
I echo what my colleagues say. I won't belabor any points. When I say echo, I had down quiet upper body, and what that means to me and what I saw all of you do was not putting your arms up here on the podium, which you see quite a bit at appellate practice sometimes. I think it's best, and you're probably taught to stand facing the court and not be distracting, not gesticulating appropriately for emphasis or as you're moving to another point so that you're just not too still. But it can be a distraction if you're putting your arms up or you're putting your hands in your pocket. You see those types of things at oral argument, and none of you did that to my recollection, and that keeps you focused on what you're saying and your face and your eyes, and there's a better communication that happens when there's not needless distractions. So that's actually a very important thing that you all did, and I thought did it very consistently across the range of questions, including my stammering, which goes to the next point. Sometimes judges can't bring the point to mind that they wanted to make, or they decide they don't want to make the point for whatever reason, and they just go off. I've seen it, and I just did it. The key to your side of the bench is to let the judge stammer around, and sooner or later he or she is going to get the footing again. But your patience keeps that conversation going, and then it just picks back up and keeps going. So you have to recover as an advocate, but you have to be patient when a judge stumbles too, because that helps get that conversation going, and it's appreciated. What was your first name, sir? Caleb. One thing I noticed about you in particular was your command of the record. If my memory's right, you were the one telling me to go to page 11 and page 12. Am I remembering that right? So a command of the record shows knowledge of the case, instills confidence in the court, and that's an important thing to do. I think you may have been the only one that said page 11, page 12. It's important. I've been asked an oral argument before by Judge Hart before she went to the Arkansas Supreme Court at an oral argument. I was making a point, and she said, "Where in the abstract is that?" I had it at hand, and she said, "Thank you," and we moved on. But if you don't have it at hand, or you don't know, or you don't show a command of the record, then your point may get lost a little bit, or it may not get returned to later on if it's an important one. So having that command of the record is quite important. I thought you all did very well, and so I commend you on your efforts. I know it takes a lot of work to learn the case law, and it also, I hope you saw, is just a fluid exercise. One of my mentors, Judge Price Marshall, calls it jazz. Brief writing is Mozart, and oral argument is jazz. You have to go with the flow. It's up and it's down. It's all around. So I thought you all went with the flow pretty well. And I had a good time being a part of this event. Thank you for inviting us. Do they have questions for us, maybe? Do y'all have any questions for us while we're waiting? Yes, sir.
Just if each of you could maybe give us one thing you like and one thing that we need to work on individually. That's something, for me personally, part of this exercise is seeing how I can improve what I'm doing good and what I don't.
I thought Mr. Woodward was very good. If anything, you're a little bit relax a little bit more when you're up there. You know, it's easy to tense up. I tense up on the bench, but that would be something that would be something to work at. Pivoting is so important. If somebody asks you a question and it kind of knocks you back and you don't really know the answer to it, pivot to your best argument, you know, and you see that all the time, probably with politicians more than appellate advocates, but still, it's adroit. It's something that serves you well if you can get back to your best argument if you don't really have the answer. And again, I thought you two did an excellent job. The microphone was an issue initially, as we pointed out, but you overcame that, and you know, that happens in any kind of event. I mean, you start a little bit slow and then you get with the program, and I thought you both did a good job of that. So.
Well, we have the results. Drum roll, please. Team winner, Team J. Respondent J. It's a very tight score, 267 to 265, so it was very close. The best oralist, Joe Woodward.